Hi, everyone. I'm Dario Piselli, Program Manager of the Jamonet module in European and International Environmental Law. This is the inaugural webinar of the new module after 3 years of implementation of our previous Jamonet module, European Union Law and Sustainable Development. With me, Professor Riccardo Pavoni, who's the academic coordinator of the module. He will make a brief introduction to today's webinar, which is, of course, something that we're particularly proud of. And then with us, of course, our keynote speaker, Professor Marjan Peeters from Maastricht University in the Netherlands, and particularly the Center for European Law. Riccardo, the floor is yours.
Just to say that, of course, as you already said, this is going to be the first webinar of our new module in European and International Environmental Law, and to say that we are particularly delighted and honored to have Marjan Peeters with us to speak today. Professor Peeters is a well-known scholar of environmental law and policy, indeed, and she is a professor of environmental law and policy at the Maastricht Center for European Law at Maastricht University. We also thought about inviting her because Professor Peeters is a co-editor of a very recently released research handbook on European environmental law, together with Mariolina Eliantonio from Maastricht University. I also have the book, so for some publicity to the book, but I think it's well-deserved publicity, because I think that this is a precious addition to European environmental law scholarship. It's a very well-thought book containing 30 chapters, and which was co-edited by Professor Peeters, as I already said. Professor Peeters is at Maastricht University since April 2008. She has written and co-edited many books relating to environmental and climate change law, and so this is her most recent realization in this area, and so we are just looking forward to her speech. So Marjan, the floor is yours. Welcome, and thank you for accepting our invitation.
So I will just now share my screen. I will be the one sharing the slides as agreed. So just maybe just a second. There you go. You should be able to see it, and now you should be able to see the slides. Can you see?
Yes.
Perfect. Okay, ready to go.
Thank you very much, and thank you for inviting me to deliver this inaugural lecture for your Jamonet program, European and International Environmental Law. And I wish Professor Riccardo Pavoni and also Dario Piselli and the whole team good luck with making a success of this program. The title of my lecture is indeed Understanding EU Environmental Law in the Age of the Green Deal. And the findings, my observations, are indeed based on my research, but also on my teaching experiences. I teach the master course European Environmental Law. The students just have had their exam already. So part of my observations will also be based on practical experience with teaching. Next slide, please. So the purpose of this talk is, on the one hand, to discuss the complexity of EU environmental law, and also then the challenge of understanding this field of law. And on the other hand, I will delve into the substance with a core focus on the Green Deal. Is it a green dream? It promises to look at zero pollution and at climate neutrality. So that will be the substantive dimension of my talk. Next slide, please. First of all, let's face complexity. I think we simply have to be realistic in accepting that environmental law is, because of its focus, the environment, a complex field. And I have listed some reasons. This is not exhaustive, but these are a few reasons that explain why EU environmental law is complex. First of all, it's actually not easy to regulate the environmental domain given its width. It's very broad. It's air, it's soil, it's water, it's chemicals, etc., nature, different species. So ecosystems are integrated concepts, but law is often not integrated, but fragmented and sectoral. So in that respect, that already provides complexity. Then secondly, there are different regulatory instruments that we can use to regulate behavior, to steer it into a more environmental friendly direction. So I have discussed with the students the different types: command and control, market-based, information-based, liability provisions. And based on what you want to regulate, a proper choice has to be made on what instrument to use. So we need to have knowledge of several regulatory instruments. Moreover, we also have to look at what the EU is. It's an international organization with 27 member states, with a parliament and a commission and a council. So the states have to be regulated as well. And we see there a mix of hard and soft approaches, so hard and soft obligations towards member states. That makes the EU unique, but it also adds to the complexity. The law is often very technical, and often we see many amendments. Technical, well, let's think about the Industrial Emissions Directive with the best available control technology standards, very technical. And if we think about the market-based approach, the EU ETS, EU Emissions Trading System, that directive has already been frequently amended with the aim to improve it, but all the amendments add to the complexity. Then, well, again, what is the EU? The EU is a very specific and valuable organization, but we do see that at EU level, for adopting acts, compromises are negotiated. Moreover, there is a need for subsidiarity, so to leave discretion to member states so that they can adopt approaches that are fit to their specific circumstances. And these compromises and the need for subsidiarity also add to the fact that the law in itself is not often already the final, clear, comprehensive set of norms. And then finally, environmental law, that's one of the most difficult things in environmental law. There is this weighing of interests with environmental protection and economic and other benefits. That's a very delicate topic. Of course, as an environmental lawyer, I would like to prioritize environmental protection, but in reality, we do see this weighing of interests, which also adds to the complexity. This is not to disappoint you. This is just to face reality, that we simply, well, we can share with each other that it is a complex field and that we have to discuss how to address that complexity then. Next slide, please. Now we move to the substance and actually to the positive news. The current European Commission, under the leadership of President von der Leyen, and with the Climate Commissioner Frans Timmermans on the picture of the slide, they have put forward a Green Deal in December 2019. And what can we wish more as environmental lawyers? There is an ambition of zero pollution in air, water, and soil. This is a dream. There is an objective of climate neutrality in 2050. Of course, we can debate whether that objective should be reached earlier, but there is this objective of climate neutrality. And also very important, the Green Deal points at rigorous enforcement, particularly in the field of energy and climate. And that's indeed something what is needed, good enforcement of already adopted norms. So in that sense, it's a dream, but unfortunately, dreams do not always come true. So we have the next decades will be very interesting, and the next years, to see how these ideals, actually these objectives, can be put in practice. Next slide, please. So let's focus then on one of these objectives, climate neutrality. This is proposed by the Commission in the proposal for a regulation. And I have given different colors to this text from the proposal to show that we can elaborate on the different elements of it in order to understand what actually is meant. We don't have time now to delve into that. In a nutshell, the aim is to have net emissions by 2050. So that if we would still have greenhouse gas emissions, that they will be absorbed by, for instance, forests, but also by other possibilities. The European Council, so the leaders of the states, of the member states of the European Union, it's a the European Council can provide political guidance, has already endorsed this objective, with one member state making a caution not to be willing at that moment to implement climate neutrality in its own member state. But as an objective, it has already been endorsed by the European Council. What is interesting, and what is very fundamental, is that the Commission proposes an EU-wide climate neutrality. So their advantage would be taken then of the fact that we have a wide territory with 27 member states, where in some member states it's easier to cut emissions than in other member states, and in some member states more capacity is available to absorb emissions. However, it is a fundamental discussion whether to move to climate neutrality in each and every member state. Some members of Parliament, European Parliament, have put forward that idea, but currently it is an EU-wide climate neutrality. So that is then a typical approach for the European Union, having a wide territory and trying to get an optimal achievement of this concept of climate neutrality. Next slide, please. We see currently a process of discussion, debate, proposals in order to achieve climate neutrality, to establish by law a trajectory to have a mechanism, a procedure to arrive at climate neutrality. But there is also a very important discussion to step up the ambition for 2030, so 10 years from now. And I have put on this slide some pictures of the Commission proposals so that you can look them up if you are interested. Furthermore, for 2021, legislative proposals have been announced to amend the existing climate legislation in order to achieve a more ambitious target in 2030. So this also already shows how much is going on. We as lawyers are very busy if we want to keep track on the current and very soon laws regulating the reduction of emissions in the European Union. It's a huge package. Next slide, please. On the slide, in a nutshell, I present to you the hard law. So this is an example. Of course, the EU environmental field is very broad, like nature protection, soil, waste, etc. But this is an example drawn from the field of climate law with examples of hard law, targets, binding targets. On the one hand, we have the effort-sharing approach with binding emission reductions for the member states, and they are enforceable also through infringement procedures by the Commission. Next to that, we have the emissions trading instrument, which has a cap, an EU-wide cap. So again, taking advantage of a huge territory, EU-wide cap that declines every year. It's a target that gradually allows less emissions. Those two approaches have been complemented now with a new regulation. It's the LULUCF, Land Use Change and Forestry. And that is an as such complicated law that aims to provide a calculation and accounting of the emissions and removals in the member states from land use change, and forestry. This is in a nutshell the hard law. The achievement of the climate neutrality objective will be complemented by other measures, many of them. but also by funding initiatives. That will also be very important to see how the financial flows will lead to achieving the aim of climate neutrality and already a more ambitious target in 2030. And on the top of this slide, you see a little block, a roadmap. This is actually taken from a message from today from the European Commission, from the Have Your Say website from the European Commission, that enables European society to take part of the discussion on the new initiatives and the new laws. And if you would go to the Have Your Say page of the European Commission, you can see that many initiatives are posted to amend the effort sharing approach, the emissions trading approach, the LULUCF approach. So really a lot is going on currently. Next slide, please. So I have just introduced to you the hard law, and now we arrive at the challenge of implementation and enforcement. And for those who want to pursue a career in environmental law, students as well, my advice would be to try to have at a certain moment an internship or a job for some time in practice. I've been serving for 9 years with the Ministry of Water Management, tasked with permit procedures and also enforcement. And I went to the ministry very idealistic, but I turned to become a realist, because there I could see that even in a rich country like the Netherlands, there are problems with governmental capacity to have sufficient staff to do all the tasks that are needed for proper implementation and enforcement. So implementation and enforcement are very important to look at. Also, we scholars have to look at that. And I've seen that in the Jean Monnet module from this webinar series, there will be specific attention to the environmental implementation review that the European Commission has launched. And those initiatives are very important. It's important to have discussions about the capacities, the abilities to implement the law. Of course, next to that, there can also be deliberate non-compliance. We should not be naive. I think as lawyers, we are trained with the fact that non-compliance is part of reality. And in that sense, the emissions scandal was, I think, a wake-up call. In the beginning of this presentation, I talked about the Green Deal as a green dream, perhaps. Yes, non-compliance is unfortunately also part of our society. And I refer to not only to the car emissions scandal, which is not on CO2 emissions, but on other emissions, nitrogen emissions, but I refer her to a case that will be interesting to read if you would like to have an idea about problems of non-compliance. This is a case of the General Court decided there, and it's about a situation where a member state approved a certain calculation approach by an industry, but where the Commission actually had the power to intervene in order to correct that prosperous calculation for the industry, because it was too advantageous and hence not in compliance with the law. This is just one example already in a complex case from which you can see how non-compliance or problems with implementation can take place. One of the problems with EU environmental law is, though, that the Commission has not much powers in order to check what the member states are doing or to intervene. So the major part of implementation, inspection and enforcement is at member state level, with not much binding law there on how to do so. Perhaps in order to fill that gap, what we can see that there is emerging soft law, so documents by the European Commission that provide information for member states on how to monitor, how to inspect, etc. That's massive in the field of the EU ETS. There are many guidance, soft law documents from the European Commission The guidance documents are not binding, but who knows, they could perhaps have a legal effect in some procedures. So that is, again, in a nutshell, an observation on implementation and enforcement. Of course, we need it in order to get the law from the books in the practice, and it deserves lots of attention. Next slide, please. Perhaps to complement eventual shortages with public authorities, etc., it's good that there are strong rights in civil society to try to protect the voiceless environment. The nature cannot speak. We see here a picture of the European lizard, a beautiful little animal, nice colors. And in environmental law, we have strong procedural rights for environmental non-governmental organizations, giving a voice to the environment. I am, of course, talking about access to information and also public participation, including access to justice to enforce these rights. So this serves as a tool for civil society to promote and check implementation and compliance. We have, however, a problematic debate in the European Union on how to provide for access to justice, particularly where it concerns Article 9.3 of the Aarhus Convention, and I quoted it here shortly. It is about members of the public have access to administrative or judicial procedures to challenge acts and omissions by private persons and public authorities which contravene provisions of its national law relating to the environment. So this treaty article aims to provide an opportunity to go to administrative review procedures or judicial procedures to contest non-compliance. However, how is this then implemented by the EU? Next slide, please. In fact, it is the Aarhus Convention Compliance Committee that has observed that the European Union is not in compliance with Article 9.3 of the Aarhus Convention. And very recently, the European Commission took action in order to try to improve that situation. And this is from the 14th of October. These are documents I have to study closely still myself. But for you, I would like to share with you that here also new developments are ongoing, among an amendment of the Aarhus regulation in order to broaden the possibility to have an internal review of Commission acts, including acts of a general scope, so not only individual acts. Next to that, there is a guidance to the member state, a communication on providing access to justice in the national orders. Thus far, it has been impossible to adopt a directive establishing this provision in the EU order. So here you see again that the Commission tries to promote that then by means of communication to the member states. So this is something that is hotly debated among environmental law scholars, like how the EU then should comply with Article 9.3 of the Aarhus Convention, on which some different views, of course, are in place. Next slide, please. So I have been talking about hard law for the greenhouse gas emissions to achieve climate neutrality. I've been talking about, as such, already relatively strong procedural rights for civil society. And meanwhile, we see a lot of litigation against the European Union, but also in EU member states against national governments with regard to climate policies, among which claims to make the national policies and the EU approach more ambitious than already regulated in the hard law. So on the top of the slide, you see a copy of my former slide with the hard law. We have that hard law, but we see that civil society puts forward claims to step up ambition. We don't have time to delve in all these different cases. It's interesting to see the different strategies. Some cases are directed directly to the EU legislator 2 cases at EU level, the 2 purple boxes. The purple boxes on the slide are cases that are still pending, but you see even more cases at member state level, among which the agenda case decided by the Supreme Court of the Netherlands, but also a Supreme Court decision in Ireland and also a decision adopted in Germany. Next to that, very recently, a claim has been submitted in Strasbourg. A couple of young Portuguese persons have claimed that the 27 member states of the European Union infringe several of their human rights. So here you see that outside the ambit of EU law, with the ECHR, a claim is submitted against all 27 member states, which are governed by the hard law of the EU. So I'm sure that there will be a lot of discussion on how to also on the strategy of going to the ECHR instead of using the possibilities under EU law, including in the member states. Next slide, please. Now we go even one step further. On top of what already is being discussed, the EU has introduced a new approach, a governance approach. That's a soft approach. It's an approach to achieve climate neutrality by means of a dialogue. This regulation from 2018 obliges the member states to adopt plans. So it's hard in this procedural commitment. The member states have to adopt such plans. But of course, there's a lot of freedom, an immense freedom for the member states on what to put into the plan. So the member states face the obligation to have national integrated climate and energy plans and to submit national long-term strategies. And this all serves to ensure a dialogue. And this is very much what the EU as well is then a dialogue between the European Commission and the member states, and also among the member states themselves. Next slide, please. This is in a nutshell this dialogue. So on the one hand, obligations for the member states to develop the plans. The regulation provides a list of topics that need to be included in the plans. And also, importantly, the regulation says that there needs to be consultation of the public. So there is a horizontal dialogue of the member states with the people, and vertical between the member states and the Commission, and then also among the member states. The European Commission assesses the national plans and has the power to provide recommendations, which have to be taken in due account by the member states. So this is then in the regulation an obligation to take due account of the recommendations. And for this whole process, we see transparency requirements. So it should be an open process of dialogue that civil society should also be able to follow. Next slide, please. So on the one hand, it's a soft approach. It does not provide substantive obligations. It provides these procedural obligations to enable dialogue. And I invite you, if you're interested, to try to delve into the regulation. In the annexes to these slides, I think the slides will possibly be distributed. I have listed a few provisions. And I must say, it's quite complicated to understand the structure. It's a truly complex framework for regulating a dialogue. The way how it operates has yet to be proven, but some elements, as I said, are truly enforceable, are put in hard law terms, the procedural commitments. So importantly, the Commission has even the obligation, in case the EU falls short of its aim, to provide recommendations to member states. And member states, as I said, have to take due account of that. And the Commission even, that's in the regulation, shall assess whether the member states have taken due account of certain recommendations. Next slide, please. Now I am entering a bit risky territory. Why? Because it's impossible, I would say, to predict what future case law will be. We don't know. Particularly with the problem of climate change, I think it's very hard to predict how case law will develop. But let me try to have a bit of a projection here. First of all, I would like to stress that according to treaty law, recommendations are clearly non-binding. Recommendations are not an act that have a binding effect. Regulations have, decisions have, but not recommendations. However, if I look at some of the case law that we have seen in the national orders, as particularly the Urgenda case in the Netherlands, where soft law is being used to interpret certain obligations, including human rights, it is, in my view, not impossible that the recommendations of the Commission will provide some arguments for national courts to award claims that ask for specific policies or for specific targets. Of course, it's very uncertain whether that will happen, but I take the position that it's not impossible that the recommendations will have some indirect legal effect. Of course, this will depend on the level of detail with regard to how member states have to improve their policies. So what detail will the Commission actually use in its recommendations? But now I would like to make a fundamental EU law observation. Because if this very uncertain legal effect will take place, hence that there will be an increase of power of the Commission by means of these recommendations that will play an indirect role in national litigation, then we do see an increase of power of the European Commission into the national policy making of the member states. And when such things happen, then it's necessary to have a good debate. A debate on the institutional dimension of EU law. Because as soon as the power of the European Commission increases, there might also be tensions with the member states. Let's suppose that in a national court, a recommendation, non-binding, from the Commission will be used to award a claim to an ENGO. That means that the national legislator will be set aside because of a certain recommendation from the European Commission. That would clearly be an increase of EU power that can be very beneficial for achieving climate neutrality, but it can be dangerous for the stability of the EU. Dangerous is a bit too strong term, perhaps. We don't know how things will develop, but I think we as lawyers, we not only should look at what is the most effective approach for the protection of the environment, but also have a good sensitivity for the use of power in such a peculiar system as we have in the European Union. Next slide, please. Is it possible to get the next slide, please?
Yes, I actually have clicked. You should be able to see it soon. Can you hear me?
Yes, I can hear you, and I see the next slide.
Okay, super.
I've almost reached the end of this presentation, and I already look forward to the discussion. I have 2 slides to go. And the first is about the truth regarding understanding EU environmental law. Perhaps it feels inconvenient for us scholars to admit that we have problems with understanding EU environmental law. And I took a decision that I would like to be honest about that. And I published an article, which is in the slide, which is about EU climate law, largely uncharted legal territory. And there I showed in the discussion how many new laws were adopted, how complex they are, and how much effort it takes to get a real understanding for it. So I hold the position that it is impossible for one single person to master the whole field of EU climate and energy law, let alone environmental law. And that's the reason why I'm so happy that more than 30 authors contributed to the research handbook of EU environmental law. Only with such cooperation we can gain common insight into the state of affairs of EU environmental law. We have developed a concluding chapter in which we have referred back to each and every chapter. So there we have tried to provide overarching observations and conclusions on the state of affairs. But it would have been impossible for Marjoleine, Antonio, and me to write a whole book on our own. EU environmental law has already become too complex for that. And in this talk, I have mainly focused on the internal dimension. I've mainly focused on climate and energy law. I haven't talked about here the second row, the external integration dimension, which means that environmental provisions can be included in policy fields, laws outside the environmental domain, also a very important dimension. And I also did not address the external dimension of EU environmental law, so the relationship with third countries and the extraterritorial reach. Those are also very important dimensions, which also have to be observed. The last slide, please.
Is it?
So, yeah,
I can. Oh, super.
I come to my conclusions then on understanding and teaching EU environmental law. First of all, we need to specialize. And for me, I'm so happy to know that I have a colleague in Utrecht University. She is specialized, Marleen Rijswijk, in water law. And if we take the European Union, we see many scholars with a kind of specialization. And with all those specializations together, if we then engage in networking, which anyway is pleasant to do, to cooperate, we can then try to reach overarching conclusions. Of course, it is important to have basic knowledge, important knowledge of the EU in itself. So to have good knowledge of the institutions, the powers of the Commission, delegated acts, implementing acts, etc., the role of the Court of Justice of the European Union, standing requirements, etc. But then with EU environmental law, we can engage into specializations, networking, conferences, and books. And then for the teaching, the way how I approach it in Maastricht, where we have 7 weeks to teach EU environmental law with 6 ECTS points. Well, the aim is to provide good knowledge of selected core topics, particularly the EU competences in the environmental field, including more stringent national action, the environmental procedural rights as a horizontal layer to the whole field of EU environmental law, including access to justice, and then some selected core regulatory instruments and related case law, including inspection and enforcement, and also environmental liability. And this is then all embedded in a good understanding of what the EU itself is. So the students have at the same time, most of them, also of course advanced EU law, so that we then have that together. With that, I would like to conclude my lecture. Thank you very much, and I look forward to the questions.
Thank you so much, Marjan. And I suppose that Dario has some issue with the connection because he's not with us anymore. So he will connect again. The problem is that he's the one who is able to read the questions. So what I'm doing while waiting for Dario to be back, just to make a very broad comment on your very interesting presentation. Of course, you were very very good at summarizing many topics here, many issues. You know, EU environmental law is very complex in itself. So, of course, it's very, very impossible to just focus very much on a single issue in just 40 minutes time. But I found your summary and your presentation very, very stimulating and interesting. And you are right to say that we will focus in our module on the problem of what you call in your conclusions the implementation deficit, because that is really, I think, there is much to say in that relation, and this is also about the future of EU environmental law as a whole. So I don't know if you can tell us something more about this area and the problem of the implementation or compliance deficit, because when I'm thinking about that, I always found that this is a kind of dilemma, no? Because in a way, we know that we have subsidiarity, we have the power of member states to take more stringent measures, etc., etc. So those elements are in favor of competencies by member states. But on the other hand, we have these member states that they are very recalcitrant, or they show resistance when it comes to a stringent enforcement of EU environmental law. So how do we solve this dilemma? What is the way forward, in your opinion? I know that there is this problem that you focus very much on the increase of inspection and enforcement powers at the EU level, but I don't know how that can be reconciled with the essence of EU environmental law when subsidiarity is so important. So I'm always confused here, and I'm trying to figure out what the future would be here. I don't know if you can tell us something more about this.
I can try. It's a very challenging question and challenging topic. But first of all, and I'm not sure, but I often observe that perhaps also EU environmental law scholars do not pay sufficient attention to the matter, to inspection, to monitoring, to enforcement, to sanctions, etc. So there seems to be a kind of love to move to new concepts, appealing concepts. I have seen, and such very important now, there is now a trend to pay attention to giving legal personality to rivers so that nature will have their own legal rights. And that is a beautiful topic and should be discussed. But I'm perhaps more of a realist nature, that I think, why don't we first discuss what we have and try to make that the best approach that we have? So that's also what I've experienced while working in practice. There are always new plans, reorganization, let's do new things. And at a certain moment, while I'm such a very progressive person, I became more conservative in the sense of don't change. Let's first implement the tools that we have. And if we do that to the best extent, then we will reach more than that we keep on changing. So that's a bit of a practical experience I have had in my own career, that I think that apparently we are attracted all by new concepts and that we delve on it, and that simply looking at, well, how is in the member states, how is currently implementation and monitoring and enforcement taking place, that is not sufficiently examined, perhaps. So in that sense, I was extremely happy to see that this is part of your module, to look at the governance approach at EU level, to look at this exchange of implementation reports. And perhaps you will arrive at the conclusion that's all too soft and that it needs to be strengthened in a legal way. That could be an important conclusion, I don't know. For that, it first has to be studied. But I looked into it a bit, and I saw, for instance, in the report from the Commission, so this is a report from the Commission summarizing the reports from member states on implementing EU environmental law. And there I saw that the Commission says that the EU ETS industries, that 99% is in compliance. So almost 100% of the EU ETS industry is in compliance. But now I need to be very careful, because from a scientific perspective, we cannot make statements if we do not examine, if we haven't examined it. So I put it forward as a hypothesis, and the hypothesis is that that there could be more non-compliance than the Commission currently knows. Why? Because, well, we don't know about non-compliance because it will be hidden. And how can we examine it? As a researcher, we are limited in our tools to examine it because we are not a prosecutor. And I think it would be very important to have a close look at how the Commission develops such statements. What are the sources that are being used? Is it carefully examined? Because it's, I think, based on member state reporting. And of course, we should also trust in principle governments. But at the same time, from a legal perspective, we know there needs to be checks and balances. So I think some more research could be done there. And if I refer to one little case in my presentation, and I really delved into that case to make a case note out of it in Dutch. And I learned so much about how indeed a bit, different interpretation of some data can lead to a more profitable situation of a company. Is that non-compliance? What is it? Well, it was not in compliance with the law. The Commission intervened. And those cases give little signs about issues that happen in practice and can perhaps happen more than we don't know. But again, as a scientist, I need to make a caution that this needs to be well examined, and we should not have general statements if we do not try to examine it.
Okay. Dario, you suddenly disappeared from our webinar.
I realized there was a sudden problem with the connection, and I'm back now, and I was here for the full answer, thankfully. And actually, I
fill the gap by already making a general comment about Professor Peeters' presentation and asking a question. But you are the one who has the ability to monitor questions from the audience. So I don't know if
indeed, and we have a couple of questions already. So I will jump into them in a moment. Maybe I wanted to say something sort of building on what you two just discussed, which is essentially sort of zooming out of the question of implementation of the enforcement of the law itself. The book, for example, the handbook, for example, mentioned also the wider role, for example, of monitoring of new technologies to being able to assist decision making and also to assist then enforcement. And for me, what is interesting is that even there, I think there's still a little bit of uncertainty in how we can make the best use of the instruments we have. So just a few days ago, the new State of Nature in the EU report, for example, was published by the European Environment Agency. And it was, a bit of an indictment of the nature legislation at the EU level. But at the same time, it doesn't seem that we are using these instruments to the full extent, because already a few days after, in the context of the EU Green Week, it was announced that a new joint research center will be created to monitor biodiversity and ecosystem centers now, and ecosystem services. Now, the European Environment Agency will collaborate with that, but it seems that there's still a little bit of an uncertainty in how we bring all the tools that we have together, especially as new tools are coming out all the time, and make sure that we use them in an effective way. And this science policy interface is strong enough at the EU level. I'm not sure what's your take on that, but.
So thank you. I think you are talking about all these new techniques with satellites, remote sensing, the new technologies that we have. Do I understand you correctly?
Indeed. Amongst other things, yeah.
This is such an exciting new development, but this at the same time immediately illustrates that, well, the limits that we as lawyers have I'm now for 33 years busy with environmental law, and it keeps me very busy. And now I need to build understanding of these new techniques. Luckily enough, I have a family member who does earth science and is very much busy with these satellite techniques. And I think, well, I see great promise there about also monitoring what member states are doing, indeed, in terms of nature protection, etc., etc. But I am not educated with that. And here we need to have multidisciplinary projects where we need to work together with scientists who know about these geo information systems, and also at EU level, because you ask for how this has to be organized at EU level with the Joint Research Center, indeed. I know there are these initiatives like the Copernicus initiative and so on and so forth. So yes, this is, I think, a promising development. Of course, it will have also important legal dimensions, privacy dimensions, etc., reliability of data, etc., etc. Yes, so I'm not knowledgeable further on that. One thing is, and that's something I still have to delve into, is the emergence of citizen science. So apart from the capacity that the EU might have with using satellite monitoring and etc. to see what's happening, the forest, etc. Also citizens, if citizens have access to such data, also air pollution data, etc. We already have the PRTR regulation in the European Union, but yeah, with citizen science, using data from the new techniques, there can be an extra power, and as you all know, power needs to be accountable. So I can expect that there will be some difficult discussions on access to data, how to use the data, etc. Yeah, I think it's a great development. How the EU should arrange that at EU level, yeah, that's something I have not really considered yet. But yeah, I saw a reference to it in the Green Deal, to these new techniques in context of enforcement. So the Commission is clearly signaling, I think, to the member states that we can watch better what you are doing, and perhaps also for your own research of your own project with this implementation review. It will be interesting to see to what extent, indeed, these new informational techniques can add to the reliability, to say so, of the reporting, indeed. That's what I can observe.
So thank you so much for the answer. I think, it's like, it kind of links back to what you were saying, that this is a moment of, great complexity and great and very rapid developments. And this is sort of the impression that one gets. We have some instruments already. We have some agencies that are supposed to support us with the science, but at the same time, we're always rushing to the creation of a new initiative because we need to take into account something more that's coming up. So that was more or less the point. Yeah.
I would like to make one, if I may, one additional observation, and that's about the LULUCF regulation. That's land use and forestry. As a lawyer, I understand from it that with this law, there will be a calculation of how much the forests absorb carbon dioxide, and so on and so forth. And I did a multidisciplinary workshop a year ago on aviation emissions. And there was a colleague, he's a specialist, he's not a lawyer, he is a specialist in forests, so an ecologist. And I asked him at a certain moment, like, is it possible to put it into a law, how to measure the emission and absorption of land use? And well, we did not discuss that in full length, but I saw some doubt there. So perhaps I have arrived at the point that we should not always think that everything has to be in the law, in the sense of hard law, because it can be that it is a topic that is too complicated to regulate, and then we should search for other steering instruments to regulate it. So I'm not a specialist on LULUCF, but I have some fear actually that this is all put in a hard law, while we will have many issues on how to interpret the law, how to measure, will it be trustworthy, etc. I don't know whether the new techniques can be relevant there. I hope so, that they would solve a bit of problem, but I don't know.
No, and indeed, this would lead us into all sorts of, discussions about, again, implementation and the role of, private actors and other networks. And you mentioned citizen science, you mentioned civil society. But I think we should really get into some of the questions that we have from the audience also. Valeria, I will show the question in a second. This question was asked by Valeria earlier on during the presentation. So it's referring actually to the whole climate plan of the European Commission, and she's wondering how much has the pandemic affected the application of the plan.
Thank you so much for this question. Because of the pandemic, we have seen a decline of emissions. All the data have yet to be released, but there are already some data that show a sharp decline of greenhouse gas emissions. And actually today I saw in this consultation by the Commission that I've showed on one slide on amending the climate change legislation, a proposal that the Commission is thinking to have an extra cut off in the ETS of the cap to align it with the current decline of emissions. So what you can read in between the lines is the idea, and I have to study the document even better. I only saw it this morning. The consultation has opened now for 3 or 4 weeks. That the Commission actually seems to be willing to freeze, indeed, the lower amount of emissions. That means then that the fact that we have now less emissions cannot be used later when the economy would restart again to have more emissions then. The whole cap of the ETS works like there is some flexibility as when to do the emissions. So that would formally mean that if you have less emissions now, you can emit more later when the economy starts again. But there is a proposal to use, to amend the law in order to take advantage of the decrease of emissions now, so that they will not be so that there will not be more emissions when the economy recovers. I hope I have explained it clearly. Yes. And there's one other element there, and that's about the effort sharing approach, which has individual targets for the member states. The member states have to comply with that in 2020, this year, but COVID happened. There were some countries, member states, that were facing difficulties with complying with it. Germany is a country that faced difficulties with complying with the emission reduction target. I assume that because of COVID, there's no problem of non-compliance anymore because of this very, very unfortunate reason. But I think it's an important warning, an important sign. If COVID would not have happened, there would have been an issue of how to comply with the individual targets. And that's a very important warning, I think.
Indeed, and if I may add, perhaps more of these questions and conundrums are sort of going to happen over the next few months, because certainly one thing that the pandemic has done, it's led to a big narrative about the idea of the recovery plan and building back better, and we have to see how this plays out then at the legal level, certainly.
And also one other change can be mentioned very shortly, and that's at the international level, where we have an approach for aviation emissions, where 2020 was taken as a base year for having climate neutral growth, So the idea on the ICAO, International Civil Aviation Organization, was to have climate neutral growth starting from 2020. But that has been changed now in the year 2019. Because if 2020 would be taken, yeah, that would have been a very severe restriction to the aviation sector. So that's also a clear development related to the pandemic.
I will jump very quickly to the other question we had from Chen, asking if what do the general decision in terms of the proposed amendment of the AURUS regulation mean, and whether the implementing acts adopted by the Commission belong to the general decisions.
Thank you very much, Shi Hang, for submitting this question. I know you're based in Guangzhou in China, so very nice that you attend this seminar in Europe. To put it short, the AURUS regulation gives only for acts of an individual scope the possibility for review by the European Commission. So not decisions with a more general scope, such as admitting new substances at the EU market. That will now be broadened, if I understand the Commission well. So this was a critique from the AURUS Convention Compliance Committee, that it was a too narrow scope of acts that could be submitted for internal review by the Commission on request of an ENGO. And that will now be broadened to acts of a general scope, such as the admission of chemicals, or, for instance, a decision on a specific derogation from an air quality standard for a member state.
I don't know if this will happen, because this is a proposal, of course, as you said, Marianne. So I think we should wait here, because if it will happen, this will be an extraordinary development in European law at large, because it will be the first time where the standing rules in Article 263 will be modified. And this will happen in the specific field of environmental law, and for the sake of compliance with international treaties, that is the AURUS Convention. So, and upon insistence of an international body, which is the AURUS Committee. So I think this will be really extraordinary for environmental law and EU law at large.
Indeed, indeed. I would like to explain a bit further. I have to read the proposal still closely, but I expect that the Commission only proposes to broaden the scope for review by the Commission itself. I think that the change of Article 263 has to be done by treaty amendments. So that cannot be changed by a regulation. That's my assumption. But then still, of course, the Commission opens then, and that's as such a new step, to have review of acts of general scope. But I think that the regulation cannot change the condition of Article 263, so that should be a treaty amendment or a new jurisprudence of the Court of Justice of the EU. But the Court of Justice of the EU has said that it's for the parties to the treaty to change Article 263. So that's still written in the stars, I would say.
Thank you. Thank you.
Thank you so much for answering also the question coming from the audience. Ricardo, do you have anything to add? Otherwise, we are slightly over time. I don't want to, of course, keep our keynote speaker for longer than we have scheduled, but please.
No, of course, I also don't want to abuse Professor Peeters' time, and so I think it was a real pleasure to be with us. Actually, I also had another comment. I'm always very much interested in every time we discuss issues of European Union law. I'm very much interested in the role of the Court of Justice of the EU, to which a lot of pages are devoted in your concluding chapter, because I think that the role of the court is key, is crucial here, as in any area of international, as in any area of EU law. But you already said something now relating to the interpretation of 263. I don't know if you want to conclude by saying a few words about the role of the court in this area?
Yes, I'm very happy to do so. Let me also start off then by saying that I actually find it quite hard to get a good picture of the jurisprudence of the Court of Justice of the EU. Why is that? Because case law is always case-based, hence fragmented. Hence, it's not so easy to draw common lines from the jurisprudence. We need to discuss and examine many cases. There are some striking things, such as, and I hope that some research or master thesis will be developed on that. I do see a lot of litigation with regard to the EU ETS, but not so much, for instance, on the Environmental Liability Directive. There are a couple of cases, particularly also memory references from Italy. But we see a difference also with the Industrial Emissions Directive. There are much less cases compared to the EU ETS. So that is already a phenomenon that needs to be discussed and examined. So why is it that some fields have more litigation compared to other fields? Another observation is, why is there so much litigation in the national order of climate change? And why did thus far no national court submit a preliminary reference to the Court of Justice of the EU? I did a case note on the agenda case where I suggested, well, I think there should have been a question for preliminary reference with the Court of Justice of the EU. And also my colleagues in the Netherlands, Bakkes and Van der Veen, they, in their case note, they observed that EU law is not sufficiently discussed in the case law. So then at that moment, well, when there's no preliminary question, it doesn't reach the Court of Justice of the EU. So there is also an issue that whether national courts, well, what is their strategy with submitting preliminary references? Then when you look at the case law of the Court of Justice of the EU, we see very progressive case law on access to information. So where it is refusals from the European Commission on requests for information, the court has been very progressive in furthering that right. On the other hand, we know that the Court of Justice is very restrictive with providing standing with Article 263, as you have said. So there we see a conservative approach. So it's a patchwork. It's a very there are many different things to say. One very important element, finally, is how the court deals with scientific complexity and uncertainty. There are cases also on chemicals, and so they are so complex with regard to the science and to is it dangerous or not, under what circumstances. And there I would like to refer to important literature from Joanne Scott and a co-author, where they see, well, the court seems to move into the direction of being an informational catalyst, urging the decision maker to make clear what information the decision maker has used. But the court can, of course, not, well, the judges should stay judges. And we lawyers, we are trained for being lawyers and not for making decisions that are beyond our knowledge, also in terms of chemicals, risks, and political balancing. So for the future, it will be very important to see how the Court of Justice indeed, well, how it will balance with giving deference to the legislator, to the decision makers, or to what extent it wants to have an influence on decision making in such complex matters with uncertain risks, etc. Those are my observations with regard to that.
Thanks. I think, Dario, we should
yes.
say thanks, many thanks to Professor Peeters. And I don't know if you have concluding words, Dario?
No, nothing more than what's already being said. I really, of course, we really appreciate the participation of Professor Peeters for this inaugural webinar. It's just the best way of kicking off the module, and we really hope that the professor will join us also for our future webinars. We hope that there will be themes that she will be interested in.
Jump in here. I mean, actually, we would prefer to have her live in presence in Siena sooner or later when the pandemic will be over, hopefully. In addition to webinars.
Indeed. Indeed.
I think I'm so happy with the fact that we have these tools now. We as a society, we were just ready with these online tools to meet in this way. So that's also much appreciated.
Indeed, indeed. And speaking of which, we will be in touch also with our audience with the sort of breaking news about any new webinar that's announced over the next few months, and we'll be happy to share it with you and Maastricht University at large, of course. Thank you so much again for everyone who joined, and yes, the appointment for everyone is for the next webinar that will be announced soon. Thank you so much for joining again.
Of course, Dario, this webinar will be available online for everybody who is not able to be present now.
Yes, it's already accessible on YouTube, so everybody will be able to see it already now, recorded.
Thanks again. Have a nice day.
You too.
Thank you so much. Have a wonderful day, everybody.